When does the savings clause of CPLR 205 apply? To find out, you have to read ACE Securities versus DB Structures. It's only 25 pages. Don't have time for that? I've got you covered. This is TLDR, too long didn't read, the case of ACE Securities Corp versus DB Structured Products, Inc. This can be found at 2022 New York Slip Opinion 03927, published by the Court of Appeals on June 16th, 2022. It's a complicated case. I'm going to try to do this in 5 minutes or less. It's a civil action. The issue here is, what does it mean when CPLR 205A says that a plaintiff, or if the plaintiff dies, its representative, can file an action under the savings clause even outside of the statute of limitations? What does that mean? Before we get into what this means, I want to talk to you about some of the law of this kind of case. The statute of limitations, you have to understand the statute of limitations and the savings clause to understand this case. The statute of limitations is a section of the law found in the 200s of the CPLR that gives specific amounts of time after which an action accrues, after which someone does something wrong, that a person can go to court and sue about it. And it's different for different kinds of actions. So for an intentional tort, you have a year. For fraud, you have 6 years. And the reason behind this is we want to limit liability. You don't want to have to worry that something you did 20 years ago or 50 years ago can come back and haunt you and you can be sued for it. So as a result, the legislature passed the statute of limitations, but they're very strictly construed. They're very strictly applied. So let's say for fraud, it's 6 years. If you try to file a case 6 years and 1 day after the fraud happened, you're subject to a dismissal motion. It's a waivable defect, but someone can make an application and say, Judge, outside of the statute of limitations, dismiss it, and they will. But think about the reason behind it. It's you want to be able to defend yourself, have notice of it. So what happened is the legislature passed CPLR 205, which people call the savings clause. And that says that if an action is timely filed within the statute of limitations, and then for some reason, not on the merits, it's dismissed, that same plaintiff, the plaintiff who filed the original timely action, can refile within 6 months, even though it's outside the statute of limitations now. Because they were originally within the statute of limitations and the defendant had an opportunity to know about it, was given notice because it was properly filed, the plaintiff can refile. So the question here that's presented in this case is, what does it mean to be the plaintiff? The facts here are, this is about a residential mortgage-backed security kind of situation where a company, the defendant in this case, DB Structured Products, gathered together, bought a bunch of mortgages, gathered it together into a bundle, into a package, and sold it to a trust that was going to take these mortgages and get money from it. And DB Structured Products made representations about the quality of those mortgages. And allegedly, those representations were wrong. So, two certificate holders, two people who were getting money on the trust, realized in a forensic accounting that these mortgages are not what they were, not what the defendant represented them to be. And so they go to the trustee and they say, sue them, try to get them to take it back or try to fix this. The trustee says, I don't want to do that. So the certificate holders file an action on behalf of the trust, and they write that on behalf of the trust, trying to get DB Structured Products to fix it. Ultimately, it's dismissed. And then the trustee tries to file an action outside of the statute of limitations. And they say, well, we're the trustee. We're also acting on behalf of the trust. The plaintiff was the trust, right? Even though the plaintiff technically was the certificate holders, they were doing it on behalf of the trust, and I'm the trustee and I'm acting on behalf of the trust. Same plaintiff. Goes to the Court of Appeals and they say, no, it's not the same plaintiff. A plaintiff is a specific party, the specific person who filed this. The certificate holders are the same plaintiff. The trustee is not the same person or the same entity or the same corporation as the two certificate holders. So they say you can't just say you're acting on behalf of the same party and therefore you're the same plaintiff. The savings clause doesn't work that way. And they basically strictly construe 205A and say that it only will protect the actual plaintiff who filed timely to allow them to file untimely the second time. Very quickly, I would be remiss if I didn't mention that Judge Wilson has a dissent where he says he disagrees and says the plaintiff here was the trust. And even though the nominal plaintiff was a certificate holder, and now the nominal plaintiff is the trustee, it's the same entity. But once again, Judge Wilson is all by himself, and the majority says it doesn't work that way. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.